Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys at the NPZ Law Group, Nachman Fawani Zimochek Law Group. We have offices in New York, in Ridgewood, New Jersey, and we also have affiliated offices in Indiana and Canada. And we're back today with Rabindra Singh, one of the attorneys here in the office. And Ravi and I are just kind of bringing the viewers up to speed with regard to a recent article which Ravi, I have to say, was instrumental in helping us to put out for the H-1B season, which has to do with what options are available. We know that a lot of you, unfortunately, 50% of you, didn't get the H-1Bs that you were hoping for on April 1st. So now the question is what to do. So we've already discussed several options that might be available to you, and Ravi and I would like to go through and discuss some of the other ones. So with that, Ravi, where are we at? L's? Or?
Yes, okay. Let's discuss L.
Sure.
And L visas could be an option for people not making 2-cap. There are 2 categories of L visas, but before I go into the categories, it's important to understand that your company should have an offshore presence if they want to process an L visa for you. So as I said, there are 2 categories of L visas. They are called L1A, that is for executives and managers, and then you need to check the regulations, how they define the executive and managers. There are different definitions for that. I will not go into that detail in this video. But there is another category is called L1B, and this for specialized knowledge workers. So when I say specialized knowledge worker, the employee should have the specialized knowledge of the company's processes, products, anything that makes this employee unique from the other employees in the job market. And that uniqueness is coming by being employed at the offshore location and gaining this kind of experience from the company's organization, from the company's processes, products, anything. It could be anything.
And I think what I'd like to do is just throw in here that with regard to the L1B, many of you may be aware, if you're watching the news or you're tuned into the immigration chat rooms and forums, you know that the L1B is a virtual nightmare, unfortunately, because this definition of specialized knowledge is not as, I wish it were as well formed as Ravi is saying, because when you say to me, what is specialized knowledge, I'll tell you, I thought I knew 5 years ago what specialized knowledge was. Now I have no idea what it is. The only thing I can kind of figure out from what the government is saying about specialized knowledge is that it has to do with a certain level of training that an employee has with regard to the products, processes, and methodologies of the business. But even when we put forth in our RFE responses to the USCIS what we feel the specialized knowledge is, they're not buying those cases. So I would say, unfortunately, maybe maybe a small percentage of the L1B RFEs are actually being approved, but it's a very, very small percentage.
Yeah, and especially for the IT companies, if they are, if you are an IT employer and you are placing your employee at the end client side, then that is going to be problematic, and it's going to be an uphill battle. But if you have an employee in the human resources department or finance department, and you are bringing this guy here in the US, then that could be easy. I mean, it shouldn't be very tough satisfying the USCIS what this employee has in terms of the specialized knowledge.
And I'll just as a quick, I'm just going to give you a quick aside, is that what ended up happening a couple of years ago, I think it was about 3 years back, unfortunately, large corporations who were utilizing the L1B were utilizing it as a sidestep for the H-1B.
Yeah.
And were bringing in individuals in L1B status, placing them out on site. And what happened was the government realized what was going on. Now this also prompted what we're going to start to see in the fall, if it hasn't started already. I believe it's actually started already, because I know that there was a stakeholders meeting online where there was a discussion about having L1 site visits. So we have H-1B site visits now, which many of you may have already encountered at your places of business, but now they're going to be L1 site visits. And again, for those of you who are properly using these visa types, It will not be a problem at all. It's not something you need a lawyer to deal with. However, of course, our office and other offices of our colleagues across the country are available to assist you with regard to site visits. However, now we're going to start to see probably fast and furious site visits for L1 visa classification.
Sure. The next visa that I wanted to talk about is the O1 visas or O
excellent,
visas,
yeah.
because there are different categories within the O visas. There are primarily two types of O visas, and before I go into the finer details, O visas are basically for you can say anybody who is an extraordinary or who is a superstar in his or her field. So it's not limited to science, education, business, or like TV production or motion picture, but it could be for anybody. It could be for a horse trainer.
Mm-hmm.
It could be for
Absolutely.
a technician.
Absolutely.
So, but there are two categories, as I said, O1A and O1B. O1A is for people who have so extraordinary
in the arts, sciences,
ability,
and business.
yes, in
Yeah.
science, arts, education, or athletics. And O1B is for people who have shown extraordinary achievement in the area of motion picture or
Which is
TV
defined
production.
which is defined merely as distinction.
Yes.
So all they have to do is show distinction, and what distinction is really that's an air ball. That's up for grabs. So it's a matter of us being creative, or your
That's
lawyer
right.
being creative for you to demonstrate this quote-unquote distinction. Now, probably most of, or many of the O1Bs that we've seen are in the areas of the arts, like handbag designers, fashion designers. We've also done O1Bs for horse trainers, as you mentioned.
That's right.
We're currently working on an O1B, interestingly enough, for areas of science and arts which which cross are areas that may not necessarily be pure art or pure science. So, for example, things like the Chinese medicine. These are areas where you might be able to make out a good O1B type of petition.
So as I said, if you are a superstar in your field, you could qualify for O visa. So there are no restrictions, like whether you are coming from a science background or arts background or from a motion picture or anything like that.
So I want to quickly discuss P visas.
Sure.
P visas are non-immigrant visas, also dual intent, as is the O. One of the common thoughts, unfortunately, is that O is not a dual intent classification, but it is actually, and it says it in the regulations. There are several different types of Ps. Ps are for performing artists and athletes, but there's a really nice classification called P3, which is for individuals who are doing things that are culturally unique. And so we like P3s for those people who are doing something like maybe they're going to be dance instructors in the Spanish dancing area, merengue. Maybe you have individuals who are specialists or know special dances. We've done some cases for individuals who have done Romanian dance from the Eastern Bloc countries, lots of Indian dancers, Indian musicians, Indian singers. So if you're doing something culturally unique, such as maybe even special cooking, maybe you do special cooking in maybe an Indian dish, a South Indian dish, North Indian dish, something like that, those are culturally unique type of opportunities which can be connected to a potential employer and might be able to give you a P3 visa. A P3 visa is good for in 1 year increments up to 12 years. So it's a really nice opportunity, and then of course you can start working on the green card as soon as you have P visa status. Let's talk about the R visa real
Sure.
quick, and it's kind of interesting just from a historical perspective. For those of you who don't know, the O, the P, the Q, and the R visas all came out of the H-1B. When the H-1B cap was placed onto the H-1Bs in 1991, the quid pro quo was to open up the doors and to allow other types of visas to make everyone happy because that cap was placed. So that's where, again, that's where R finds its genesis. There are three different types of R visas. R1s are for rabbis, priests, and ministers. R2s are for professional religious workers, and R3s are for individuals who are serving in traditional religious function roles. So if you are a religious person, if you're involved with your church, if you're involved with your temple, or you're involved in a religious organization, and this is an option, please present it to your qualified immigration professional and let them explore the opportunities for you to move to an R. R is not dual intent, interestingly, but after serving as an R visa for 2 years, you can move to the green card, which is an EB4 classification, and it's pre-certified. So it's a really nice opportunity to get to the green card in a really quick way. Yeah. So that's R. Yeah, I think that. So with that, I think what we've done is explored most of the options that are available. However, there may be others that are available. There are different programs that, again, we on a daily basis dwell in this world. So we might be able to come up with something for you. Again, it's really important for us to sit down and talk to you. I think I want to emphasize that immigration is not cookie cutter, because I know that if you're in the chat rooms and you're in the immigration forums at night, you may think that the answer is the same for everyone. Oh, my friend did this, or oh, my friend did that. And I get that all the time when people call. Oh, my friend did this, so I can do that. But it's not really like that. So the most important thing, and for any of you who have already communicated with our office, with Robbie, with me, with Lutko, with Michael, you know that we always ask for a resume. And then we also push you to have an initial consultation with us, because we explore with you through these initial consultations some of the options that might be available. I'll give you an example. Yesterday we had an individual who came into the office who came in with a thought that he was going to do a particular type of case. And it turned out that he couldn't do the case at all. In fact, he was misdirected by the legal counsel who he was talking to. After he sat down with us, we put our heads together, came up with an option that was going to work for him. And it was based on facts that he didn't disclose to his prior counsel, that we had to elicit from him. So again, please understand that having an initial consultation is so worthwhile and so valuable for us and ultimately for you. And also having a good solid resume with everything on it so that we can understand what it is in your background that we can marshal in your best interest for immigration on a going forward basis.
Yeah, and this is a very creative field, and this is a dynamic field that keeps on evolving every day. So you better discuss with an experienced immigration attorney before you finally decide which route you want to take.
And speaking of creative and emerging, in our next video we're going to talk about the upcoming H-4 possibility for work authorization. So stay tuned, but thanks very much for tuning in with us today.